Good evening, everybody. The Zoning Board of Appeals meets tonight in conjunction with Massachusetts General Laws, Chapter 40A, and other applicable laws. Tonight's hearing will be conducted in the following manner. The Secretary will read the legal notice or state that such notice has been waived. All applications will be heard. No, they will not be heard in the order they were received in the City Clerk's office, because tonight we are taking number 8 first. Just a little change. The petitioner or petitioner's representative will present the subject application to the board. What that means is, if you have an attorney or a builder that wants to explain why you're here, they will. Are you having a hard time hearing me on that side? You okay? So instead of me going through all of this and then explaining it, let me just explain it now. So when it's your turn, you'll come up to the podium, you'll state your name and address for the record. If you have a builder, an attorney, an engineer that's going to speak for you, then they will do the same thing. They will come up on your behalf and give their name and address for the record. They will then, you or whomever, will then tell us why you're here. Now, I know that we have it in front of us, but we also like to hear from you what you're doing and why you're doing it, okay? Then we'll have some questions for you, maybe, maybe not. And then I will usually or always say, is there anybody in the audience to speak in favor? If you have neighbors that you already spoke to and they want to speak on your behalf in a positive manner, which is always to your advantage, then they will come up to the podium, give their name and address for the record, and tell us what a wonderful neighbor you are, and they are all in favor that you're building this garage. I then will say, is there anybody in the audience to speak in opposition? Once again, hopefully your neighbors are okay with what you're doing. Sometimes they are not. They will come to the podium, give their name and address for the record, and they will tell us all the reasons why you should not be building this garage. If that happens, you or your builder or whomever can come back up to the podium, state your name and address again, and you can sort of discuss the reasons why you don't believe whatever your neighbor said, hypothetically. That's basically how it goes. At the end of all that, the board may ask a few more questions, and then we take a vote. So, I have to say, this is, I believe, to be extremely, extremely, extremely fair board, and I also think we are on the lenient side. However, not everything can be approved. So some things are denied, because if everything was approved, you wouldn't need us. You could just get your building permit and go on your merry way. So at that point, we take a vote. It's either approved or denied. There is a 20-day appeal period that you have to wait for, if you are approved, to do any building. And our clerk, Ms. Carla McGrath, will explain all of that to you tomorrow after this is over. The decision is typed and filed with the city clerk, and once that decision is filed, that's when the 20-day appeal period begins. When you are at the microphone, please speak directly into it. You just press this little button once, and it turns red, and then you know you can speak. I encourage no talking from the audience. I don't mean to one another. I mean, if somebody's up here speaking and you're concerned with, you're connected to whatever they're saying, please don't talk from your seat. We'll give you another chance to come up to the podium. If you are speaking in opposition to something, please keep it to the subject. We are here for dimensional relief. That's what we deal with, zoning laws and ordinances. We don't deal with neighborhood baloney. So I don't want to hear that your neighbor is a lousy neighbor because you haven't spoke to them in 10 years and their dog keeps you up all night. We're not concerned with that. We don't want to hear that, and I won't listen to it. So, cell phones on vibrate, and practice what you preach. If I knew how to do it, there you go. And so I think that we can begin. Thank you.
First on the agenda tonight is number 8. It's an application of Peabody Access Telecom, Inc. for a variance from the provisions of zoning ordinance 2020 as amended, section 7.1.5, as it applies to the premise known as 81 Main Street, Peabody, Massachusetts. Petitioner seeks a variance to build a detached garage and requires relief to accessory structure located in front yard, side setback where 10 feet is required and 5 feet is proposed, accessory structure size where 500 square feet is allowed and 640 square feet is proposed. The property is located in a BC zoning district.
Thank you, Madam Chair, members of the Zoning Board of Appeals of the City of Peabody. My name is John Kelty. I'm an attorney. I have offices at 40 Lowell Street in Peabody, Massachusetts, and I'm appearing on behalf of Peabody Access Telecommunication, Inc. They seek a variance for an accessory garage at 81 Main Street in Peabody, Mass. Their central headquarters is located at 81 Main Street in Peabody, Massachusetts. In this instance, that main building is at the rear of the lot, as close to the rear lot line as just several feet. We are proposing a garage that would be at the front portion of the property, an area that is currently available for parking. When we build this garage, it'll house the Peabody Access Cable Mobile Television van, and it will be made up of brick with transom windows. We have been actually before the city in various capacities for the last several months. We've met with community development. We've been through the planning board. We have had our materials and the look of the premises. The elevations as well have been approved by the planning board, and we have included those elevations and the like in the package that was filed with this board. So we seek a variance that does three things. One, allows us to build an accessory structure in the front of the premises. Two, allows us to build with a 5-foot side yard, and that is a matter that we have vetted with our neighbors on that side of the property, and they are working with us and aware of that 5-foot side yard. And then the third variance that we seek is for the structure itself. 500 square foot garages are allowed. However, ours is 640 square feet, and we would ask that you grant all three variances. We would ask that you understand that the matter has been under the provisions of the downtown business central design standards, has been through that process, and at a late date it was determined that the provisions that we seek this evening do in fact apply to the downtown business central area. As such, we would respectfully request that you grant the series of variances that are presented this evening. Thank you very much.
Thank you. Questions by the board?
Thank you. Through the chair, Attorney, could you just elaborate on, you say you're working with the abutter. Is there a problem with the abutter? Does he have a problem with the...
Prior to the prior to any application made to the planning board and/or community development department. That's a property owned by Maria Carrier and her family. We met with them in as much as there are some challenges with respect to they have little terraces up on the top floor. They explained to us that those are likely to be enclosed and turned into additional indoor living space for those units on the roof. So we were able to kind of coordinate with them their timetable along with ours. And there's a vent that sticks out from their building. We discussed how we would be able to locate our fire connections and our electrical boxes and the like without interfering with them. So we're on the same page.
Okay, thank you. I have no more questions.
Anybody in the audience to speak in favor? Anybody in the audience to speak in opposition? Hearing none, the matter is before the board.
Motion to close the public hearing.
Second.
Motion to approve.
Second.
Roll call vote.
Yes.
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 Yes, you have been approved.
Thank you very much.
We are now moving on to number 1, which is a continued administrative appeal of J.D. Raymond Transport, care of Attorney Kimberly Croha. Ms. Croha?
Good evening. Thank you all for your time again on this matter. As the board may remember from last time we were here, we had filed the zoning appeal on the basis of the wetlands. The owner of the property did file a request for superseding order of conditions that allowed them to skip local conservation commission review. We did have a site walk, a fairly lengthy site visit with DEP on October 4th, and DEP has the matter under their jurisdiction and reviewing whether the project as proposed meets the State Wetlands Protection Act. So my request tonight is just to continue to December to let that go, or if continued to November, to accept a written motion that would continue it to December if the DEP review of the project was still open.
This has been on our agenda for a few months now. We're waiting for the EPA to render some sort of a decision. And I would like a motion to have Commissioner Tellerico add the EPA approval step to CB-370 in the permit approval process. If approved, 27R Farm Ave will need to upload their findings to the permit, and no further meetings with the ZBA will be required. This permit will stay on pause until this happens.
So moved.
Second?
All in favor?
Aye.
Any opposed? Okay.
Thank you.
So this will then be continued, Carla, till November, or till we hear from EPA? DEP, yeah. Okay. Got it. Department of, got it. Okay. That's all set. Number 2 is a continued application of Attorney Jason Panos from the provisions of the zoning ordinance on 25 Farm Ave, and we have an update? Attorney Panos.
Good evening, members of the board. My name is Jason Panos, practicing law at 246 Andover Street, Peabody, Massachusetts. Here on behalf of the petitioner, the residences at Farm Avenue LLC, the property owner and holder of a comprehensive permit at 27R Farm Avenue and 0 Forest Street. Yes, we do have an update, but before I get into that, there was a comment made by the attorney for J.D. Raymond on September 19th, and I want to briefly address that comment. She indicated on behalf of J.D. Raymond, and I quote, that we sought through a lawful process that we were entitled to pursue, that we were evading local review. Evading, the use of the word evading was intentional, and it implies that we did something illegal and unlawful. And between the two parties here, there is only one that is evading, and that is J.D. Raymond. They have been cited, obviously, by the building commissioner. Their current use is illegal. They are out of sorts with the requirements of the local wetlands protection ordinance and the Wetlands Protection Act itself. And so I take mild offense to the use of the word evasion against us when it is most appropriately placed at the feet of J.D. Raymond, Trucking and Transport. This matter has also been on your agenda for a very long time. It's been on your agenda since April, when we applied. It's been heard and continued time and again. And to give you a sense of perspective, we've been asking time and again for a timeline for compliance. And as I said, to give you a little context, the Peabody Fire Department issued a cease and desist against J.D. Raymond Trucking back in February 2022. They're still not in compliance. They filed their notice of intent application with the Conservation Commission in April of 2022. That's more than 6 months ago. They're nowhere near receiving an order of conditions. In fact, their last filing before the Conservation Commission was on August 30th, and they sought just last week a 2-month continuance of that matter before the Conservation Commission. I mentioned at that September 19th hearing that they would not receive the order of conditions from the Conservation Commission by the end of the year, and I'm right. Not because the Conservation Commission or its peer reviewer, Horsley Witten, are dragging their feet. No, because of continuances and continuances being asked for. And I suspect there'll be another continuance in December. Who knows? And also, on top of that, they're nowhere near filing a special permit application that they're required to file before the City Council. What does all of this mean? Well, for example, the matter before the Conservation Commission, they can drag out by regulation for another 2 years. They have another 3 years to build it. That means that their incentive is to really drag it out to perpetuate their illegal use for another 2, 3, 4, up to 5 years, without consequence and without question. Think of that. And let's put this into further context. We, at 27R Farm Avenue, built a crossing over a resource area under the microscope of the DEP, the local Conservation Commission, the Army Corps of Engineers. We sought for a project, by the way, much more complicated than theirs. We sought the same special permit and obtained the same special permit that they need to come into compliance. It did not take us 1 year. It didn't take us 6 months. It took us 3 months to get all of that accomplished. So I would ask through the chair since we've been talking about timelines and deadlines for over 6 months now, I would ask through the chair of Attorney Croha, who has to have broached this subject with her client, what they think is an adequate timeline for compliance. What they think is an adequate timeline by which they'll get out of conservation, come into compliance with the city council, and obtain their special permit. I don't think the question's ever been asked. I'm dying to know what they think and how long they think it's going to take. And with that, I think the matter is before the board, and I once again would ask that you impose a timeline for compliance that moves them away from this perpetual kind of attitude of continuance. Again, they're going to drag this out as long as they possibly can so that they can continue their legal uses without question or consequence. And think for a moment what that is, what message that's sending to other actors, bad actors, who might be operating in this community. That if you wait it out, if you sit back, do your thing under the radar screen, it's okay. So I think this board is the last line of defense to prevent that. And I think we can make a decision tonight to just stop this, move it along, get it off your agenda, and make sure that they're in compliance. We're not out to shut them down. We want them to abide by the same laws that we've had to abide by time and again. Without anything further, I really would like that answer to that question posed, again, through the chair and through this board, to Attorney Crowe. What do they think is an adequate timeline for compliance? Thank you.
Attorney Croha.
Hello again, Attorney Crowe for J.D. Raymond. Attorney Panos and the residents at Farm Ave have asked this board to review the appeal that they filed from the building commissioner's earlier determination under section 15.6.2A of the zoning bylaws, which requires this board to make a determination in their favor to have found that they're aggrieved by their inability to obtain enforcement against J.D. Raymond. On August 31st, the building commissioner submitted a letter to this board saying, I can affirm that if any different position is taken, which is explained in the rest of the sentence, other than compliance with CONCOM and a special permit, I will shut down their operations. That certainly sounds like enforcement to me. Yes, our next Conservation Commission hearing is in December. Yes, our last filing was in August, but we didn't receive the peer review of that filing until September 30th. And although our engineer thought that he could get the materials together by the end of October filing deadline for the November hearing, we had a conversation and decided we didn't want to be forced to submit something that wasn't complete. And so we asked for the December hearing, which was granted, so we can submit our materials in November. We are moving forward with the application. We cannot draft or file a special permit until we see what the final product looks like after conservation. There were a lot of comments outstanding, and we're working very hard to accommodate those and figure out different aspects of the project between the topography and the test pit results that came through just a month or two ago. So we are working on that process. The board is being asked to determine whether or not the neighbor of ours is entitled to zoning enforcement relief. And they just aren't. The building commissioner has taken action, and he has promised to take further action if J.D. Raymond doesn't live up to its promises. And what I would ask is for the board to either deny their request for zoning enforcement or suggest strongly to them that they withdraw it without prejudice to refile if that point comes when Conservation Commission has voted on the application, and if they do not believe that a reasonable time period has gone by before filing for a special permit. But I can't say what that time frame looks like without seeing what the project looks like at the end of the Conservation Commission proceedings. So, thank you.
Through the chair, Attorney Croha.
Yes, sorry.
I would like to, setting aside whether you believe enforcement's been taken or not by Mr. Tallarico, I would like an answer to the question, what's a reasonable time frame from your perspective?
A reasonable time frame is if the project is permitted the way that it is now, I think 60 days. But I don't know that that's what the project's going to look like when we come out of Conservation Commission. We're going through some serious design aspects of it. There was just a letter from the Planning Division that discussed some of the mulch piles and other things that are around the site. So we're not here today for a use determination, so I can't say with certainty exactly what a reasonable time period would be once we see what the final project looks like at the end of the Conservation Commission proceedings.
Okay.
I would like to comment that this body did at one point continue this until we actually got a determination from the Conservation Commission. So I think that's reasonable, obviously. If we were to impose a deadline, it would have to be at least after the next meeting. I don't know if this body's willing to do that now, but that's just my recollection, so.
Through the chair, yeah, I remember that. I have somewhat of a differing opinion this time compared to last time, just because now we're looking at a further 2-month continuance with Concom. So it'll be back before Concom in December, which means our December meeting, there's unlikely to be any kind of productive update for us, which means the next time it's going to be potentially productively before us will be January, which would be between 8 and 9 months from the time this was first on us. We've already heard it, so before us 5, 6 times. It'll be 7, 8, 9 times almost before us. I'm getting a little worried. Is this going to be before us in perpetuity? We don't have a timeline from Attorney Croha able to say what they even believe is reasonable at this point in time, and I'm not faulting you for that. I understand there are hoops you need to jump through, but we don't even have that. So it leads me to believe we just have this open-ended situation before us. So I'm inclined to say we've done what we can do on this. Let's set a deadline, even if it's 90 days out for our January meeting. Something to create some sense of urgency here. So we can't dictate what Concom does, but I think we have to create a sense of urgency. It is an illegal use.
So, and I agree 100%, but if everything is depending on conservation right now, and in December, if they still haven't made a decision, then how can we even do anything in January?
Well, I think we'd have the right at that point if Concom came to us and said, by way of a memo like they do so many times, there's active participation in this or something along those lines there, that's a different story. But if in December there's minimal activity or a request for another continuance, now what? Now we kind of have not that we have our hands tied, but we're in a spot there.
Yeah, I would say it's conditioned on what participation the petitioner has. So if Concom does tell us that they weren't prepared to go in front of them in December, we can make that decision. Right. But then, if I remember the calendar, so the Concom, I think, are we going to have the meeting in the same week? So
I think we might.
So that means ours is first. So we would have to wait till the January meeting. And I would say, if we wanted to continue it till then, the condition would have to be that if Concom doesn't receive everything that they've requested to make a determination, then we can act accordingly.
And I guess one question I have is, I know we're being told that a special permit can't be drafted until Concom makes its order of conditions, but we were previously told that a special permit is drafted and ready, just pending Concom's decision. So I don't have an answer to that. I suppose honestly, if it was just me, I would like to see I'd like to see a special permit drafted and filed, even if it's premature, just something to show that something's being done in January or February. I mean, I can't tie Concom's hands and say, you got to do something. But I might feel differently if it wasn't an illegal activity. And we have Al Talarico's opinion that this is, in fact, an illegal activity. If this was just some other dispute, it'd be different. And I feel like it's just kind of letting this sit out there is problematic in time.
I did. Would it be helpful to the board if the conservation agent, Brendan Callahan, gave you updates? If the board would like, you could make a motion to have updates over the next couple of months from the agent on record. Just an idea.
Through the chair, there's a lot of things being said from both sides, and I'll be honest with you, I can't make the determination who's right, who's wrong. Are you dragging your feet? I don't know. He thinks you are. Are you? No. Are you complying with everything that they want? Are you providing all the information in a timely manner? If you are, then I have no problem with that. I certainly respect the other side's opinion that you are, but I have no proof. My problem is if we put a timeline on, right, and we find out that they're going through the process in a timely, correct manner, we're really going to end up extending the timeline, right? Now, I think Kyle had a great idea. As we get communications from Concom and we determine that, hey, wait a minute, they had plenty of time to do this, they didn't, that's going to change it. As soon as that happens, that we get the communication, I think next meeting we definitely put a timeline on. But I'm not comfortable doing it right now because I don't know who's not going through the process. Well, it's an illegal activity that the building inspector chooses not to stop. He'd rather control it. He's the guy. If that's what he chooses to do, do I agree with it? Probably not. But we asked him how he's enforcing it, and he told us.
If I may, Barry, I think you hit the nail on the head. I'm sorry.
Yep, so when looking at the commissioner's determination, he does say in that last sentence that if J.D. Raymond decides not to apply for a special permit, I think at this point now it is predicated on the decision in Concom. Although I'm with Steve, if they don't find that they have everything they need in December, then this is something we have to take up. It is.
So I guess if that's the case, can we set I don't know, is there a deadline we can set for the January meeting?
Well, I would expect that if it goes in front of Concom in December and everything that they've asked for has been complied with, they'll make a determination at that meeting, unless they decide to take it under advisement. But if they make a determination at that meeting, that special permit better be ready to go.
Right, because what kind of threw me tonight a little bit was just that there's a continuance.
Right.
And on this board, we know obviously that things come in, they need to be continued because of peer review or whatever else. But it's been before Concom for quite some time as well. So seeing a 2-month continuance after a special permit was supposedly drafted, it bothers me.
But what if it isn't? What if Concom doesn't make a decision in December?
I mean, I think we'd have to collect that data and make a determination. It's something that would be up to us at that point. But we did put this condition on it prior to this meeting. I think it was at the last meeting.
Yeah.
So I'm just inclined to abide by that for 2 more months and then reevaluate. But that reevaluation will be under a stricter standard that Steve's been talking about. So.
Yeah, and I would certainly like to hear from Brendan much more frequent, well, not his fault, but much more frequently so that we know what's going on at Concom. Is the applicant there not producing documentation? Are they not responding in a timely manner? Is it a city issue? Like where's the disconnect here that is taking this long?
So if you made a motion for Agent Callahan to attend the next meeting, the next few meetings, and give you an update and answer those questions that you have, that would probably work.
Through the chair, Attorney Crowhigh, you're still at the podium. Did you have a list of receivables that are outstanding to the Conservation Commission, and what would that be, and what is your time frame for supplying that to that body?
So September 30th, we received the peer review comments, and so there is an updated set of drainage plans. And when I referenced drafting the special permit, it was drafting the plan that goes with the special permit. The text itself is done, but I don't have a plan to see what that looks like. There's discussion about where the infiltration basin is located and whether that's an appropriate location. So we're looking at relocating that, whether it goes in a different area. What that means. So it's basically the plan set and the written submission in response to the peer review comments. I will say it's likely that Conservation Commission is going to want another peer review of our plans when we submit them. I can speak with Acting Agent Callahan and see if we can get permission to work directly with the peer reviewer so we can try to get that accomplished before the filing deadlines for the December meeting. But that is the only sort of red flag that's going off in a time frame. But I could see if this board were inclined to continue the hearing until January, getting the updates along the way, and I'd be happy to, when we submit the plan, submit a letter just summarizing what went into Conservation Commission so that this board is aware without having to read the entire Conservation Commission submission. And that way you all have a good regular basis of knowledge of what's happening.
Yeah, so not knowing the basis for their continuation, I'm wondering if it could be appropriate, even though this whole item has been continued to December, is if you had plans ready prior to the November meeting and those got submitted, you could actually get on the agenda to find out if they'd want those to be peer reviewed, and then that could be accomplished by the December meeting, if you follow me.
Yes, I think because that could work. I can't remember exactly how they continued it, whether it's on the public meeting for November to have any discussion, but it seems reasonable that we can try to work with that general idea.
Yeah, if that's an option, I'd like to see if that could be carried out.
Attorney Panos, before I
Yes,
this?
thank you. Excuse me. So 2 points of note. The Horsley-Witten peer review memorandum that got submitted was the second. So there were lots of open questions, and there continue to be open questions. I will also tell you that Friday afternoon, Brendan Callahan submitted a proposed condition to conservation regarding pile heights. That would be a condition to the order of conditions that I suspect would ostensibly be carried over to a special permit. And the recommended condition would be to take the pile heights down for unfinished product from 60 feet to 25 feet, for finished product from 60 feet to 15 feet. I'm really happy that planning and Brendan and conservation are working in that regard. I think those are great conditions to begin with. But the bottom line is, and what I began to say with regard to Barry, there's nothing wrong with setting a timeline and moving it if there is appreciable progress toward the ultimate goal. You know, we're not out to shut them down. We're out to seek compliance, like we sought compliance. So if they're on the road, great. I've said it before. We won't object to further continuance to allow them the breathing space to continue and finish up. But if they're not, what's the matter with the timeline that you would impose? And I think we're generally on the same page in that regard, but I just want to make that clear.
So
Thank you.
what did you say? There's an email from Brendan Callahan?
It's a memo. It's
And
a
you got
memo from him to the Conservation Commission.
And Carla, at some point, do we have access to that? At some point, can we?
I didn't receive it, but I can talk to Brendan tomorrow.
Okay, so I think at this point, we're all feeling that this honeymoon is over. And we'll make, Mr. Zelotes will make a motion as such.
So I'll make a motion to continue this. No, we're going to do it before I make the motion. So we're talking about in December, we meet before Concom, or Concom meets before us? So they'd be before us. So the motion I would make then would be that we continue this to the December hearing. And that during that time period, Agent Callahan will provide us regular updates with what has been happening at Concom as far as submissions and peer review or whatever activities are going on with Concom, and that this matter come before us at our December meeting for essentially a final review as to whether we're going to apply a firm deadline or issue a cease and desist.
Fran? I have no speaking. I think, Stephen, I think it'd be important to have Brendan here in case we have questions, not just provide updates, just have him at the next 2 meetings.
To amend the motion, have Brendan Callahan here for our November meeting and for our December meeting. Thank you.
Just to note, this agenda item will stay on the agenda for next month and the next month. It has to carry through, but you wouldn't have to appear until December. Or you, because Brendan will be coming, we still need updates from everybody.
So then I guess I would amend the motion to request that the applicants, at least through their attorneys, appear at the November meeting to provide updates concurrently with Brendan.
Are we all set with that motion? Do we have a second? All in favor?
Aye.
Aye.
Any opposed? Okay, that's good. Thank you very much. That was productive. Believe it or not. Believe it or not. 2-minute recess? Already?
Already.
Okay, everybody, now on to number 3, which is another continued application. However, the applicant has revised plans and no longer requires a variance. Applicant was asked to submit a letter requesting to withdraw without prejudice. Nothing was received. Is anybody here for number 3? I need a motion to close the public hearing.
So moved.
I need a motion to withdraw without prejudice. No? Well,
Can we just dismiss it?
Well, perhaps we can bring it again.
Yeah, just without prejudice, they can bring it back again if they want.
okay, well,
They
go
have to refile it. All right, so we'll move to allow them to withdraw without prejudice.
Second.
all in favor?
Aye.
Any opposed? All right, now, number 4, application of Josephine Cook.
Next on the agenda is item number 4, application of Josephine Cook for a variance from the provisions of zoning ordinance 2020 as amended, section 7.2, as it applies to the premise known as 25 Glendale Ave, Peabody, Massachusetts. Petitioner seeks a variance to subdivide a lot where existing dwelling and garage are on Lot A, and new construction is proposed on Lot B, and requires relief to lot area where 15,000 square feet is required. 10,000 square feet is proposed. Lot A, 10,000 square feet is proposed. Lot B, lot frontage where 125 feet is required and 100 feet is proposed. Lot A, 100 feet is proposed. Lot B, the property is located in R1A zoning district.
Thank you, Madam Chair, members of the board. My name is John Kelty. I'm an attorney. I practice law at 40 Lowell Street here in Peabody, and I'm appearing this evening on behalf of Josephine Cook. She is a resident of 25 Glendale Ave. Her lot currently, if we look at the assessor's map, contains a dwelling and garage, significant sized garage, and she is located on 20,000 square feet total. The zoning in this particular district is for 15,000. Most of the properties in the area are in the 6,800, 7,000 square foot range on Glendale, also extending over to Fairview Ave. Most of these lots were developed in the late 40s, early 50s, and as such, they were developed with a different zoning in mind, and they do conform to zoning. Currently, the requirement is 15,000 square feet, and we are proposing 2 lots, Lot A and B. Lot A would contain the currently existing premises at 25 Glendale Ave, and the proposed lot, which would be another 10,000 square foot lot. Each of these will be 10,000 square feet. Each will have 100 feet of frontage where 125 is allowed. And Josephine is proposing to build a new structure on what would be Lot B. No glasses, Jack. Yes. Lot B, and we're proposing that would be a structure which would be in accordance with the neighborhood. It would be 2 stories. It will not exceed the required height in the area. However, the first floor will be complete living space so that Josephine would be able to move from her current premises at 25, build the new structure, and it would be complete with first floor living, sleeping, everything would be there so that as Josephine gets a bit older, quite a bit older, she needs to be to need this, she would be able to enjoy the premises without moving on. The second floor would be developed, however, the master bedroom would be on the first floor. The second floor would just be bedrooms that would be, at this time, unneeded, but would be utilized in the future, perhaps. The goal is to build a space that would be suitable to allow Josephine to stay on the premises, to stay where she grew up. She has, we are aware that there is a wetland behind us. Eastern Land Survey has prepared a plan that shows the wetlands presence as it relates to our property. There is an elevation that is at the back of the lot that we're hoping to build on. That elevation is approximately 80. From there's a slope downward, which goes into an area that is a wetland that has, in the past, there has been some flooding. There has been significant work done on this particular wetland areas of outlets that were clogged and unpassable have been opened up. In the last several years, keeping in mind that Josephine has lived there this entire time, in the last several years, there has been no flooding. We will need to go to the Conservation Commission. If you allow the creation of the lot, the structure that we're proposing requires no variances. The existing structure requires no variances in as much as the only non-conforming side yard is an existing side yard to the side that is already developed. And so we can build this structure if we were to leave here tonight and be approved for the 2 lots. We would then apply to the Conservation Commission seeking their approval of the construction of the premises, and it will in all likelihood require that all of our new impervious area, rooftops, driveways, all be provided with detention facilities so that water running off these newly created impervious areas would be available. We would create a chamber that would be able to collect water on the premises. We will have an immediate need to account for our own water. We do have area on the premises that if the Conservation Commission were to see fit that we were to make that a bit larger so as to provide some extra storage on the property, we have the ability to do that and would be happy to do so. The Conservation Commission is likely to take into account the change in the flooding circumstance that had existed there but has not existed for the last several years. There is also a mosquito program that had been undertaken by the city of Peabody, and that involved cleaning out some of these overgrown areas so as to discourage the spawning of mosquito beds and the like. That has been done. That has also contributed to the control of water in the area. This summer, because of our drought, that area was not a threat to anyone or anybody. As we get into a rainier season, we do see that while there is more water in that wetland area, it is not exceeding that elevation 80, which is currently the highest that we would usually see it at. Currently, the water is well below that elevation 80, and we're hopeful that you would grant the variance, which is frontage and area, and that would allow the signature to be applied to an A&R plan, and we would then go to the Conservation Commission for their approval of this desire. Thank you.
Jack, do you have
Josephine is here this evening, can answer questions you may have.
to go to the planning board also?
No. Planning board would be on what's called an A&R plan. They just sign the approval not required plan if you give me the variance.
You would just go to conservation for their approval?
We need to be both places, correct?
Through the chair, Attorney Kelty, I believe you said a multi-level, two-floored house?
Two-floor would look like a cape.
In the application, it says to construct a one-level living home.
I meant that to mean that the Josephine could live on one level. It will be 2 stories, but it won't exceed zoning. It'll look pretty much just like all the other houses in the neighborhood.
In my understanding, this application was filed times before and denied. Is that accurate?
It was filed with the Conservation Commission, and we couldn't get through the Concom.
If we approve you tonight, you still might not get approval by Concom.
That's true, but we feel optimistic because of the work that's been done already on that ponding area behind us, and also given Ms. Cook's discussions with 7 of her immediate abutters who have indicated their favorability to the plan.
Love your enthusiasm.
Yeah, I just want to comment through the chair. It looks like it would be pretty much in line with the rest of the neighborhood, even if the lot got split. So I think our only determination is that. We don't have to worry about Concom on Jack's behalf, so.
Just a comment for the board. I live in this neighborhood. We're yet to see if any of these repairs have addressed the flooding issues. There was a significant apparatus put in the ground recently that is still above ground. We're waiting, I'm being told, we're waiting for that to hopefully settle. It's a significant flooding issue over there. My family personally has totaled cars in that area in these floods. This body of water is rather large. That apparatus, I don't know the technical term for it, is going to take that additional water coming from the top of Granite Road Extension and divert it into this body of water now. If things worked out the way they were going to, they were going to divert it all down right into Brown's Pond. That didn't happen. This apparatus is put in the ground, and it's going to discharge out into that pond. There's a lot of water there. There's a lot of water there. I'm concerned with the project. I don't understand the need of it. The applicant lives in a house next door. I don't understand what building a new house is going to accomplish. I'm on the fence with this one.
So builds a new house on land that's probably going to flood it. The other, where she lives now, is that going to be sold?
The likelihood would be sold, yes. Sold so that this one could be built, yeah.
Anybody in the audience to speak in favor? Anybody in the audience to speak in opposition? Opposition, if you do, come up to the podium, state your name and address for the record, please.
Good evening. My name is William Delp. I live at 13 Granite Road. My name is William Delp. I've lived at 13 Granite Road for 55 years. I'm a butter to that wetland, and it's a real fragile area. We've had tremendous problems with flooding in that area. That lot that she would like to build on It's been times and the whole lot has been just about underwater. I've seen the water up as far as the sidewalk on that lot. She's applied before, it's been denied before. When the councilors went down and looked at the lot and saw how high the water would come up, it was denied. I'm very, very concerned about filling in that lot, tapers from the sidewalk down into the wetland. If they build on that lot, they're going to have to fill. And that pond is a retention pond. The water that comes down from up a Granite Road extension and all that Boulderwood area, it drains down into that area, and it's some serious flooding. I did a presentation a few years ago, and they just did a $400,000 project on Granite Road, Mountain Terrace, to try to alleviate the flooding. And all that water goes right into that retention pond. And if they start filling that retention pond at all, it's just going to raise the water table. And I've watched the water come up in my sump hole higher and higher. Every time someone's encroached upon that area and enlarged their yards by putting a little fill in there, the water table has gotten higher and higher. So I am very, very concerned about any fill or any addition to reducing the size of that wetland.
Thank you. Attorney Kelty? Was there mention of fill? I'm not even sure that's legal.
No, we're not filling. And we don't fill the wetland. We won't be able to. There will be no request to fill the wetland. What I did say was that there would, the elevation of 80, which is currently showing on your plan that was filed this evening, that's sort of the top of the bank, and then thereafter is where the wetland technically begins. I don't disagree with Mr. Delp that in the past there has been water right up onto almost to the sidewalk. We expect that condition is much improved, and we further expect that we can make improvement in that circumstance by building the new structure and providing adequate storm drainage and infiltration ponding area, infiltration tanks and detention facilities on the premises, so that that will enable us to get through the conservation filing, I'm hopeful. But the things that my client is proposing to add will result in great improvement on the site, but really can't go anywhere without the proposed variance that we're seeking tonight that would allow us to take step 2, which would be to design so as to make significant improvement to the area. But we are not proposing fill.
Good evening. My name is Thomas Kench, 21 Glendale Avenue, Peabody. I talked to Ms. Cook, and I told her I was opposed to it before. I got a few pictures here if you want to see how the backyard looks like. All right. And that, where she's going to build is right in the wetlands. I mean, they've been throwing leaves in there to make it look better for the last 10 years. You know, I talked to her. She said she wanted to be out of her home and on the first floor level. Now she's proposing another house with 2 floors. You know, she could have, easier these days to just put the bedroom on the first floor of her present house or in the garage, transfer the garage, you know, to a bedroom. That's all I've got to say. All right, thank you, folks.
Anybody else? Yep. Yes, you may.
I heard someone mention, or Mr. Kelty said there was work done in and around that area. The only work that was done that I know of is to increase the flow of water into that wetland. There's been nothing done to get the water out of that wetland. And as far as, one-floor living, I can attest to that. I'm 77 years old, the wife and I, we were thinking of moving, we were thinking of remodel. We just remodeled the bathroom, and we plumbed up a closet for a washer and dryer. We are now one-floor living, very reasonable to do that rather than build another house.
Anybody else? I think maybe we should have a site visit.
Through the chair, if I could. I hate to mention my past life, but in a past life, I know a lot about water in Ward 1 in Peabody, and this is a troubled area, all right? But I think I'm wearing a different hat now, though. We're here for, will it fit into the character of the neighborhood? Yes, yes, it will. I mean, anybody that's gone down Glendale Ave knows the house lots aren't 10,000. I mean, they're not 15,000, they're probably not 10,000. This is a product of the new zoning ordinance. And I guess my question is it really up to us to determine whether flooding's an issue for not subdividing a lot? That's what I'm having trouble with, and you can say one-floor living, one-floor. If you own the land, you can build whatever you want. You can live on the roof if you want to. It's your land. You can build the house. Now, if you choose to build it on where it's going to flood, then, I guess the onus is on you, not this board, I don't think. I mean, if we look at that lot and if we can subdivide it, and we probably, in my opinion, we can. It fits the character of the neighborhood very well. I guess it's up to her to take the risk about building her house there. Is it up to us? I don't know. Is it up to conservation? It would be up to conservation, I would say, seeing that that's conservation land.
So to Barry's point, I always have to remind myself of what filter we make these decisions
Yeah,
through. And the filter we make these decisions through are enforcement or providing relief from just the zoning ordinances. We don't have any other purview. It doesn't mean that we can't look into it further, and it doesn't mean that if somebody alters the flow of natural water in the neighborhood, as Stephen can attest to, that's a liability issue.
Right, exactly.
Again, not our issue. We only are vested with the authority on certain issues, and Barry's just stated what they are. So I don't know, I think there might be sentiment for a site visit.
Yeah. Might help. It would help, yeah. I mean, I don't need to. I've been by it 100 times.
I don't think Chris does either, he lives over there.
Yes. Absolutely.
I think that my client would like to speak.
Hi. Josephine Cook, 25 Glendale Avenue. I'm sorry. Josephine Cook, 25 Glendale Avenue. I understand everything you're saying, and I just wanted to clarify a little bit. I've lived there for 30 years. I don't want to move. I recently had a hip replacement and a couple other things which showed me that eventually I'll need a house with everything on the first floor. The way my home is set up now, the inside and then the garage, it would be difficult to do aesthetically and functionally. But the other thing is they did the work, and on the mosquito people were supposed to pull up all the overgrown vegetation behind Glendale Avenue. Excuse me. And I spoke to the mayor, and he said it was done, but it was actually done on Granite Road. And he told John Turco, the counselor, that they're going to come back and do the area that's overgrown again. And I just...
Not concerned with that.
Oh, I'm sorry. I'm so sorry. Okay,
I do have a question, though.
yep.
Didn't Attorney Kelty say this is a two-story house, and you just said you want everything on one floor because of your...
But I still want a house that if I had to have someone come in and help me, or I'm just trying to stay out of a nursing home. But,
Okay.
okay, I was going to say one more thing, I'm sorry. Oh, if, I guess it's mandatory now to put the detention tanks in, but I would be willing to get one that's much bigger if it would help the surrounding area drainage. Thank you.
Okay, that's good. Thank you. Anything else to say, or are you all set? And nobody else to speak, is that correct? Okay,
I'll make a motion to close the public hearing.
Second.
Motion to approve. I guess we can condition upon Concom approval.
Right.
But, and planning board.
Second.
roll call vote.
Yes.
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 Yes. Approved. Let's hope you...
Thank you
get-
very much, Counsel.
Okay. Number 5 is Jamie Marquez.
Number 5, item number 5 on tonight's agenda is an application of Jamie Marquez for a variance from the provision of the zoning ordinance 2020 as amended, section 7.2, as it applies to the premise known as 4 Will Sawyer Street, Peabody, Massachusetts. Petitioner seeks a variance to construct an addition and requires relief to rear yard setback where 35 feet is required and 32 feet is proposed. The property is located in an R1B zoning district.
Hello, my name is Luis. This is my wife, Jamie Marquez, and this is our contractor, Daniel Porter. He's gonna talk. He's gonna do the talking.
Let's hear what happened.
Daniel Porter, I'm the construction supervisor. The license, the permit was pulled under. 55 Holton Street, Peabody. Sorry. Do you have the first set of plans that, because there's 2 additions being applied for. One was applied for. When we applied for the second one, the mistake of the first one was discovered.
To explain what's going on, please.
I came in as the contractor. Somewhere I was made to understand that the addition, which looks like it's penciled in, was penciled in by a previous contractor. The dimension for the setback isn't clearly indicated. In fact, it's hardly indicated at all. I assumed, the building inspector also assumed, went to... Okay, well,
Thanks,
that's
sir.
not the original one. I'm sorry? Okay, I did attempt to upload it.
Going on.
Okay, well, the
This is the
setback
same as
line
this, right?
or dimension looked like it went to the existing addition going out the back.
Oh, yeah.
No, that's where I had penciled in.
Okay, you know what? If we
looks
can't,
like
if we
this.
can't get
Oh,
on
yeah.
the same page, we're not going to hear this. We need the right plans, and if we don't
okay,
have
we
the
don't
right
have-
plans, we're not going to hear it tonight. So what do we have? Okay, I'm sorry, we do not have the right plans. What you have is late correspondence. We do not accept late correspondence on the night of the
Okay,
meeting.
well, I had,
So,
Yeah.
what?
What's the date of the plans?
What's the date of the plan you have?
June 21st, 2021.
Well, we have
We don't have that one.
We have July 6th.
I only got one.
No, it's in there, since they're spread out.
2022. Okay, so on ours, more up to date?
Oh, yeah. Oh, I thought they were the same.
Yeah, but what about this? The big one?
Yeah, I have three. I have June 21, 21, July 6, 22, and August 4, 22. But those are the August 4, 22s for a newer proposed addition that does not require a variance. So I see a July,
July, August.
so I see a June 2021.
All right, so we do have a June 21 plan.
Showing a proposed addition, presumably within the proper setbacks. And then I see a July 6, 2022, so approximately a year later.
Yeah,
showing
so
the
I'm looking
entire-
at the June 21 plan.
Okay.
And you'll see, well, that was the first edition that we built. And you'll see in the back corner, the back right corner, the addition 11.3 by 12 foot, and then the setback of 35.3.
Yeah, yeah.
Which is, it was not clear to me where that mark went to. Was it to existing, or was it to what I thought was a general contractor had penciled in, we can do it this way for so much? The second set of plans dated the same, which have the penciled-in addition squared off with existing addition, is what I submitted to the building department. It's the same date, except that it's been modified. You can see the clear straight pencil lines as opposed to what looks like a pencil lines.
Through the chair, if I may. All three plans look like none of this exceeds what the existing structure is right now. Am I reading that correctly?
Correct.
So,
So they would have to take this down, this nice feature wall, 25 feet long with a fireplace and a television in the center of it, and move half of it into the house 2.5 feet.
so the relief that they're looking for seems to be on all three plans, because, I mean, it doesn't exceed the actual setbacks that exist as is. I mean, unless I'm missing something.
No, it doesn't, it's the same setback as what currently exists.
Right.
Currently existed pre-plan.
Right.
Right.
So to comply, we'd have to take the half of that room and move it back 2 feet. The other half, which is existing, could stay out that 2.5 feet.
Right, if he goes by the setbacks that exist, but it already presupposes the setbacks
So the reason they didn't
relief
apply for
requested.
a variance was because they thought they had setbacks?
Yeah.
Okay.
Yeah, so it looks like based upon this June 21, 2021 plan, it just blankly says 35.3 plus or minus.
With no indicator where it goes to.
Right, it looks like this, I'm guessing the confusion was, does that go to
The property
the
line.
existing point, or does that go to the proposed addition? Looks like it ultimately went to the proposed addition without any indication it did so.
Who did these plans? I mean,
Which brings us to the second set of plans. On the next edition, he accused me of fraud for modifying his plans. So we thought we were on the up and up. We're going to submit for another edition on the other side of the house. Those plans got rejected because they were as silly as the first plan, by the building inspector. Said, no, I can't take these plans. They look like what got us in trouble in the first place.
to legitimize this building.
Fran, just, I don't know what the heck I'm looking at.
Well, he wants another addition to the right, to the left side of the house.
No, what it looks like to me is that
We shouldn't be
that-
figuring this
No,
out. We need to be
that-
told
that's my point.
exactly what you want and what you're doing here.
Hi, I'm Luis, as my wife Jamie, we're the homeowners. We initially, when we bought the house 3 years ago, there was a room that is 15 feet out by like 12 and a half. So we wanted to box it in, open up the kitchen, and just add a family room, open living space for the family. Like Daniel said, when we got the plans, we gave them to the inspection, they approved it all. And when we're moving forward now to do another addition on the side of the house, we got the same guy to do the work because we didn't think we did anything wrong, so we're trying to just use the same guy because we had a good rapport with him. He came, he did the measuring, and then he said, oh, you guys didn't follow my plans. And we were like, I don't know what I'm doing. You know, I gave my contractor the stuff, and it got passed by the, those people, yeah, the building department. They passed it all, and, you know, now we're sitting here concerned that someone's gonna tell us we have to knock down 2 feet of, you know, huge addition that we just did.
So you are here for a variance?
Yes, ma'am.
For 2 feet?
Yes.
That nobody knew was wrong because you hired, I'm not going to say it.
McNamara.
FIA and Parsons, whatever they're called.
Stephen.
I did go around to all the abutters. I talked to my neighbors, and, you know, nobody, I don't know if anyone's here or not. I don't think so, but everybody seems to be okay with
Anybody
it.
in the audience to speak in favor? In opposition? Okay, let's see if we can just figure out this
Motion to,
debacle one more time.
motion to close the public hearing.
Okay, excuse me?
No.
Yeah, we're good.
Okay, so should we close the public hearing now?
Yeah,
All right, so motion to close the public hearing.
second.
All right, so before we put it to a vote for discussion, but my understanding is that we have a June 21 plan for initial proposed build. The build ultimately gets brought out so it's even with the rear of the existing building.
Yep.
Then that's all approved.
Yep.
Subsequently, a new addition is proposed on the left side of the property.
Right.
When that's done, it catches the attention of the building department. They say, wait a second, no problem with that, but the rear is a problem.
Right.
You have 32.5 feet, you need 35, so they're here seeking a 2.5-foot variance for the rear yard.
Right.
That's my
For
understanding.
something that already exists.
Something that
That's
already
all I
exists.
understand.
Something that already exists.
And through no fault of their own.
Right.
Right.
So,
So, I don't know who's to blame, but I don't know if you should hire or talk to those people again. The public hearing, let's,
So with that discussion, oh, Chris, you guys. So with that discussion, I'll make a motion to approve.
second?
roll call vote.
Yes.
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 Yes, so you've been approved for your variance, but be careful from this point on. Thank you.
Sure.
Number 6. Go ahead.
Number 6 on tonight's agenda is an application of Owen and Julie Romans for a variance from the provisions of zoning ordinance 2020 as amended, section 7.2, as it applies to the premise known as 5 Mount Pleasant Drive in Peabody, Massachusetts. Petitioner seeks a variance to construct a fala addition to the left of the home and an addition to the right side of the home, and requires relief to left side yard setback where 100 feet is required, 13.8 feet is proposed. Rear yard setback where 100 feet is required, 70.8 feet is proposed. Right yard setback where 40 feet is required and 22.4 feet is proposed. The property is located in a BR zoning district.
Good evening. My name is Julie Romans. I live at 5 Mount Pleasant Drive. I'm the homeowner. We are looking to remove a garage that's on the right side of our home and rebuild with a family room and bedroom. And then on the left side of our home, we are looking to add a in-law apartment for my parents so that they can take one of the bedrooms on the first floor and an additional couple hundred square feet for a family living room on the other side of the home.
Just through the chair. So this proposed addition on the right side,
Yes.
is that being built on the same or nearly the same footprint
This-
as what exists?
It's an 8-inch difference, so it's
Okay.
23.4 inches now, and it's going to be 24 by 24.
Okay.
Excuse me, Carla, was this FALA already approved by the building department?
We also have wetlands behind the house, so we've already been to the Conservation Commission and been approved there last week as well.
Fran, through the chair, just a question to the applicant. You said the father on the left side and taking a bedroom as well?
Yeah, so it's a Cape-style house, so they're taking a room on the first floor that's our bedroom and going to add a family room, and they're going to have a bathroom.
So that's the 15 by 11 bedroom on the
Yes.
bottom?
Yes.
Through the chair. You're going to take an accessory structure away. Do you plan on adding another one at some point, or you?
No, we do not use the garage at all, just
Okay.
storage, so.
Okay.
Fran, through the chair as well, again, any conversations with your neighbors?
We've talked to all the neighbors, nobody's in opposition to it. We have a business on one side of us at 3 Mount Pleasant Drive, American Construction Corp., and then the house on the other side, they had no opposition, across the street, was not opposed to it.
Anybody in the audience to speak in favor? In opposition? Any other questions by the board? Hearing none, the matter is before the board.
Motion to close the public hearing?
Second.
Motion to approve?
Second.
Roll call vote.
Yes.
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 Yes, you've been approved.
Thank you.
Number 6. No,
Number 7 on tonight's agenda is an application of Artan and Adelina Lesage for a variance from the provisions of zoning ordinance 2020 as amended, section 7.2, as it applies to the premise known as 7 Sheffield Drive, Peabody, Massachusetts. Petitioner seeks a variance to build an addition that requires relief to side yard where 15 feet is required and 3 feet is proposed. The property is in an R1A zoning district.
Good evening to everybody. My name is Adelina Leshai. I live at 7 Sheffield Drive. I live there with my husband and our 2 kids, but recently joined my father-in-law and my parents, so it's a little crowded there. And on the side door, we would like to put a roof up there and make a mudroom to leave at least shoes or coats or things like this. Would be easier, so the kitchen would not always be wet during the winter. So this would help us to make our life better there. We already talked to the neighbors, and nobody's against. The neighbor on the side also gave me an approval, a written one. So,
So, through the chair, I'm looking at the picture of the property.
Excuse me?
This is your property.
Yes,
So this little jog out here,
yes.
you said you were going to put a roof on it?
No, that is the project. That's the
That's
entrance without the
so
roof.
this is exactly, there's nothing here now, just a
No,
door?
it's a balcony and the side door, the stairs, but there is no roof on that. We're going toward the back, but not toward the side so not on the side of the neighbor. We're keeping the existence one.
Through the chair. So just for clarification, the landing's already there, you just want to enclose it?
Yes.
Okay.
It's already constructed. The side, the balcony, we just want to close it,
Sure.
to do a mudroom there.
Yep.
It's sort of like, I think it's sort of like what's on the house next door to me, how he enclosed it. Anybody in the audience to speak in favor? In opposition? Any other questions by the board? Oh, and my microphone wasn't even on. Go ahead.
Motion to close the public hearing.
Second.
Motion to approve.
Second.
Roll call vote.
Yes.
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 You've been approved, yes.
Thank you very much. You have a good night.
And now we are on to our 40Bs. Yay. Once again, we're going to start with 128 Newbury Street, but just one more time, I just want to say this for the sake of maybe people listening that are listening and people that didn't hear it the last time. When a builder decides to build in the city of Peabody and he finds a prime piece of property and decides, oh, I think I'll make this a 40B, it has nothing to do with the Zoning Board of Appeals. We do not say, yay, let's go ahead and do it. We want you to do it. We have nothing to do with this. They go to the state, and the state gives them their approval. Once the state gives the builder the approval, the most that we can do is compromise to make it the best project we can for the builder and for the city. Believe me when I tell you, it is extremely difficult to deny a 40B. And I said it last month, and I'll say it again. Short of being built on, you name it, the San Andreas Fault, a volcano, it's difficult to deny this. We tried, we had a denial before, unanimously voted by this board. It went to the state, and they told us, go back and compromise, which we did. And we're waiting for that to be built. So there's been a lot of talk about all the 40Bs in the city of Peabody. And we're the last stop, unfortunately. We're the ones that have to listen to it. We're the ones that have to make the decision. We're the ones that hopefully do the best we can for the city of Peabody. But we are not the agent that goes out and looks for this. It comes to us. We are the last stop, and we are trying to do our best to compromise and to make these, believe it or not, 8 40Bs are before the city of Peabody. We're trying to do the best we can with what we're given. It's a tedious, long process, but, you know, we just keep on plugging away until a decision is finally rendered. That being said, we have a continued application of the 40B comprehensive permit known as 128 Newbury Street. Mr. Slattery, could you please read the motion to accept all these correspondences? Oh, you're chewing, I'll do it.
Sorry.
I gave everybody candy. We need a motion to accept the following correspondences. September 16th, Langley memo including. September 12th, World Tech Memo, and 9/9, Horsley-Witten Memo, Peer Review Proposal. 9/13, Langley Memo, including 9/12/22, World Tech Traffic Review. 9/19/22, Langley Memo, including 9/19/22, Horsley-Witten Memo. 9/23/22, Langley Memo, including 9/21/22, Ty and Bond Sewer Review. 9/28/22, Response to Burnson Memo. 9/29/22, Updated PNS Agreement. 9/5/22, Langley Memo. 9/5/22, Horsley-Witten Memo. 9/5/22, Weston and Sampson Memo. 9/16/21, Utilities Plan. 1/8/17, Proposed Drainage Improvements. I need a second.
Madam Chair, I'm done eating, and I second.
All in favor? Any opposed? Okay, all those memos have been accepted into the record, and now, Mr. Kelty, may we have an update?
Yes, you may, Madam Chair. My name is John Kelty. I'm an attorney here in Peabody, Mass. with offices at 40 Lowell Street in Peabody again. I am happy to say that I'm here to provide an update. I did, prior to this meeting, I did provide 7 copies of what I'm about to present this evening. In as much as in its totality, it is somewhat redundant as to the fact that you've just received all of the communications that I'm about to mention. But I would like to say that at the last meeting, we did receive specific comments from the Zoning Board of Appeals at your special meeting on September 19th, and there were some poignant questions that I can answer this evening. We were asked to provide a comparison of the parking ratio that was proposed for the 220-unit design, and then what that ratio was for the 180-unit design. And the ratio, when we were proposing 220, was 1.57 parking spaces per unit. And with our 180-unit design, we have now a parking ratio of 1.73. There was a question to provide clarification of whether the proposed development will be serviced by gas. We will not be utilizing gas. We have removed all gas services from the design and from the plans that are currently under review. We were to provide information and documentation regarding WPA jurisdictional buffers within and around the property, so we did. And it is within the documents that I gave to Carla this evening. We provided you with the negative determination of applicability that was issued on June 10th, 2021. It documented no jurisdictional resource areas exist on the subject property, and a copy of that Form 2, the determination, has been provided for your reference. With respect to soil management, there were questions provided that were these soils, was there contamination on the property? Yes, there is contamination in that general area. There is a well-identified plume. Trammell Crow is buying no contaminated property. We have cut out of certain areas that were originally thought to be purchased. They were part of a now defunct subdivision. We did not buy some small strips of that particular subdivision, or will not buy those strips due to contamination. And however, we need to and will follow every requirement with respect to properties that contain AULs or are working with a known commodity. So all of our soils brought onto the property or brought off the property will be tested and tested in the 21E protocol and handled in accordance with the law. We have provided in that memorandum a status of our peer reviews. That is somewhat lengthy. It really kind of documents, it really indicates where we are with each peer review. There are 4 peer reviews being conducted. Horsley Witten is looking at our drainage and stormwater management and at the environmental. We are down to, with our third review of our plans by Horsley Witten, we're down to providing some elevations for our there are elevations and dimensionals that need to be revisited on page C504, and they are elevations near some of our detention containment facilities, stormwater management facilities, and we're in the process of doing that. Ty and Bond is reviewing sewer availability. Both Horsley Witten and Weston Sampson and Ty and Bond have said, for purposes of that the Johnson Street pump station must be revisited. We're working with Bob Langley as to what it will cost to repair the station, what design will cost, and a variety of other costs. We are aware that we have an I&I fee that will be tacked on to this. It is the possibility that our I&I money could be used towards that. That's a question for this board and Public Services Department. And we are still in traffic review. World Tech is providing us with our with respect to Weston and Sampson, we need to add a water line that will improve our fire flow, and we've agreed to do that, and we're in the process of showing that on our plans. World Tech has wanted us to model specifically at certain unsignalized intersections with Route 1, and most notably our intersection with Route 1 from our driveway. We're in the process of remodeling that for them. We are adding materials to on our erosion controls as requested by your peer reviewer. We believe that there are a number of items, we've seen that there are a number of items in which our peer reviewers have all stated that it's up to the Department of Public Services to weigh in on a couple of matters, and we're waiting for the Department of Public Services to make a recommendation to you folks, and those issues would be included in any eventual decision. There is one more matter that, they've asked us that anywhere we're showing stormwater detention, that all of those be with the covers to any access covers all be graded, and that there be graded like openings, like storm drain grates rather than solid covers. All of these matters are well within our reach. We expect in a very short period of time to have closeout memorandums from all of our peer reviewers. There are a couple of questions that I think are going to fall to the board. We did have a visit on site in which we walked the driveway to this property and looked at its interaction with the honeydew. We have designed some apparatus for the center of that proposed roadway. We would rest if the treatment of that center line. We have provided materials that would make it very inconvenient for you to make the left into the honeydew, and also would make it very inconvenient and virtually, and not impossible. Nothing is impossible. There are crazy drivers that will go against the grain almost every time. However, they've made it extremely difficult to come from our project to get over onto Winona Street. Our neighbors have, at the outset of this project, have been very adamant about our not utilizing Winona Street, and we will not be using Winona Street for any bus stops or for our access and egress. That'll all be directly from Route 1. There'll be no access egress, even as emergency for the fire department from Winona. And with that, we're happy. I'm again going to point to the fact that we did this summary has been filed in writing and will become part of the record along with the correspondence that you alluded to this evening. So if there are questions that are on the minds of the board with respect to our treatment of that driveway and how you get across, I would like to hear those, and if you have suggestions along the way as to how that might be improved. Otherwise, we're going to stand pat and utilize the driveway in the fashion that we've demonstrated in the past and shown on all of our plans. I'm happy to answer questions that the board may have this evening.
Okay, I have some. So do you have the updated purchase agreement? Was that done? Okay. And you did do the response to Stacy Bernson's, yep, you did that. Did you provide a revised parking plan that reflects 180 units?
Yes.
Tonight?
No.
Okay, so
No,
we have not seen that yet, because you,
Well, the parking plan
yep.
is included in the set of plans that shows the 180 units. And what I was trying to point out was that ratio has changed. There's more parking.
Right, but we don't have that yet, right?
Yes, you do.
We have,
You have the 180 unit plan, and that's part of it.
okay. Tell me about the Johnson Street pump station.
Street pump station appears to, right now, I don't think it's online. I don't think the city of Peabody utilizes it. I recall that from years ago when we were trying to have the subdivision that was on this property being approved. And at that time, there was an issue with the Johnson Street pump station as to its pump. We've had a discussion with Mr. Langley. Mr. Langley is looking for information as to what the costs associated with the replacement of that pump are. He's also looking at other source areas that might be able to supply for us more information with respect to that cost, and then he will make a recommendation as to what our role will be in making improvements to the Johnson Street pump station.
So is this the pump station that you access from basically across to get to Saitani Park?
Yeah,
And
roughly it's down there.
And
yes.
it almost hits.
So you would wind down Winona, and then you get down in the vicinity, not quite where Pine, Winona, John, and join, and it's closer to Route 1 than that spot I'm talking about right now. But yes, you're right.
So it's not the whatever it looks like. It looks like a pump station that is almost to the walkway, to the
To Saitani?
walking path.
I believe you're right.
Right. So that's not near Pine Street or anything.
Well, there's another facility down that they took offline too on Pine Street, but
That's not Johnson Street.
that's not mine.
What about so this center roadway apparatus, is that, I don't have it in front of me right now, is that distinctly shown on plans?
Yes, that shows on a specific sheet on our set of plans, and it was
What
blown
it looks
up.
like and, okay.
Yep.
All right, well, it looks like there's still some work ahead of you here, Attorney Kelty, a lot of work, but that's good. I wonder if, Mr. Ryan Cox, do you want to say anything tonight?
No.
Okay, Ryan, so remember now, we're going to listen to everything you have to say, but we can't have a discussion, okay? Thank you. Name and address for the record, dear. No, you have to turn it on. There you go.
Ryan Cox, 11 Hamrick Road, obviously Peabody. So I did have one question that maybe you guys can answer for me. It pertains to a timeline. So a public hearing closes 180 days from when it was opened.
Mm-hmm.
So that was opened on May 16th, and that would put today's date at 154 days. Is this going to be continued?
I guess the simple answer is we don't know. We don't decide on whether it gets continued or not. It gets requested by the applicant and put before us. That has not happened yet, so none of us can speak to whether it will be or not, sorry.
So my concern with that is there still are no plans. They have not been submitted. There's not a full set of 180 plans. So also, my concern is, a lot of things have been said, and I haven't really seen them in writing. One of them was when we did the site walkthrough. It said that they had access to other properties, but it was contingent on if it was leased at that time, but they have the right to lease it within 60 days. So what is the scope of work that's going to be done to the abutting parcels of property? Once again, maybe the plans will answer that, but we don't have them. So there's a lot of questions that can't really be answered. And, you're going on 3-4 months without plans. I just don't understand how an applicant can come before the ZBA and not have plans of what they're actually doing.
I'm not going to answer any of that, but I just want you to know, Rye, that what I don't want you to do, and what's not very polite, if in fact that's the way it's coming across, is that don't think that this zoning board doesn't know exactly what it's doing. I know that it looks like there's no plans here, the plans came in late, the zoning board, but believe me when I tell you, this is a long and tedious process, and we have yet to do any 40Bs within 180 days. They're always continued. And all of this is never going to get approved unless it's 100% done correctly. And I relish your comments, but please don't make assumptions that we don't know what we're doing. And I'm just saying, no, I don't want you to comment. I don't want you to comment. I just want you to realize that, we do know what we're doing.
Okay, and I totally understand that. And maybe I'm asking questions because I don't know the answer to them. As far as the 180 days, there's questions that I've never done.
Keep asking because I'm taking notes.
Okay. I think they clarified the answer about, or the concern that I had about the contamination of sites and whether stuff would be tested and whatnot. And that's pretty much it. Yep. The only other thing that I noticed was the Weston and Sampson shows the drawing that they submitted shows gas on it still, so I'm going by that plan, and it shows 220 units, not 180.
And I thank you for all of this. And let me just also remind you that anything that you need that's public record, you can always ask Carla.
Yep, which I know.
Thank you very much. Anybody else wishing to speak on this matter?
Move to continue to next meeting,
November 21st.
November 21st?
Second.
All in favor?
Aye.
Any opposed? Okay, this is continued to November 21st. We're now going to hear the continued application of our next 40B, 58, the Residences at the Mills 58 LLC. And you are going to accept the correspondence, yes?
On this item, move to accept correspondence, 9/16/22 Langley memo, including 9/15/22 Horsley Whitson second peer review stormwater, 9/15/22 World Tech updated response traffic, 9/16/22 Weston and Sampson peer review, 9/14/22 Attorney Flanagan memo, 10/11/22 Hayes outstanding issues, including, and 10/13/22 Hayes memo and Horsley Witten stormwater peer review. Second, anybody?
Second.
All in favor?
Aye.
Any opposed? Okay, how about Attorney Panos giving us an update?
Good evening, members of the board. My name is Jason Panos, practicing law at 246 Andover Street, Peabody, Massachusetts, for the applicant, the residences at Mills 58 LLC. Some administrative matters before I begin. Are you also in receipt of Bob Langley's memo from this morning, which purports to close out all of the peer review? Excellent. Is that something you'll also receive on the record? I have a copy of it, yep. Hold on. Hold on a second. Let me give it to you. You have it? It's dated for today. Here it is. Excellent. Do you need to accept it?
Yeah, we do. All right, motion to accept correspondence from Langley, Director of Engineering, dated October 17th, 2022.
Second.
All in favor?
Aye.
Okay.
So a brief overview. We started out at 51 units. The plans evolved to a 45-unit rental apartment dwelling. The hearing on this application was opened on May 16th and continued to June 6th, continued through July 18th, when we went through a lot of peer review discussion, and continued again to August 15th, when peer review updates were again given, and continued to last month, September 19th, when tonight's hearing was designated. Since that time, as we just noted, all peer review items have been resolved. We have internally reviewed the conditions proposed, and we are on board with all of them. Again, to recap, 45 units, 5 3-bedroom units, 20 2-bedroom units, 20 1-bedroom units, proposed for an overall 65 bedrooms, 101 parking spaces for a parking space ratio of 2.24 spaces per unit. You'll recall the benchmark we try to achieve on 40Bs is 1.5 spaces per unit, so we well exceed that. And the other benchmark that World Tech, your peer reviewer, likes to see is 1 parking space per bedroom. We are at 1.53 parking spaces per bedroom. Obviously, this is an apartment proposal, so all 45 units will count toward the city's SHI. We propose that up to 70% of the affordable units, that is 3 out of the 5, I'm sorry, that is 5 units will be set aside for local preference, meaning those who live in the city of Peabody, grew up in the city of Peabody, but can no longer afford to live here because of exploding housing costs. Those who have a tangential relationship to the city of Peabody, kids and schools and so forth. As I indicated, just a brief status update. The city, through its Department of Public Services and Department of Planning and Community Development, and the mayor's office have worked constructively and collaboratively with the applicant's development team over the past several months to conclude peer review. Peer review was conducted within the requirements of applicable regulations at 760 CMR 56.05. Peer review was conducted through your contractors, Horsley Witten on environmental and stormwater, World Tech for traffic, Ty and Bond for wastewater and sewer, Weston and Sampson for water, all paid for by the applicant, exhaustively reviewed the technical aspects of this application, including the stormwater and environmental status of the property, traffic, stormwater, and water connections. We submit to the board, and Tony, I will invite through the chair to give some more of the technical presentation, but we submit to the board that we are ready to close the hearing. At least we suggest that because our peer review and an agreed set of conditions have been established. And at that point, if the board wishes, I can walk you through once again kind of the technical timeline of what I would propose if you wish that. Okay. So with that, Tony, you want to give the technical?
Thank you. For the record, Tony Capichetti, Hayes Engineering, 603 Salem Street, Wakefield, Massachusetts. I'm the engineer for the project. I'll be very brief. As Jason had mentioned, we've gone through the peer review through the four major aspects. We've reconciled or have a plan to reconcile all these items. Working with Bob Langley, he's drafted a set of 12 conditions that we're more than happy to incorporate into any decision should that time come. We've also had the abutters here previously. They submitted some information, and we met with them last Thursday. I think it was a pretty productive meeting. We discussed some of the bulk of their concerns centered around the off-site parking for the commercial uses. And we sat down and brainstormed with them, their engineer, their attorney, and came up with some minor modifications that would be submitted at the time that we have to apply with the city for that off-site parking. But we provided them with a quick red line sketch showing, how we could incorporate what they're looking for, relocation of some of the parallel spaces that may affect their property, and widening the pavement width back to 30 feet in that area. These were all received pretty well by the abutters, and I'm sure you'll hear from them later on tonight. I'm not saying that we've satisfied all their concerns, but I think we've made great progress. And up through the point where we file that, the next plan with the city for the off-site parking, it's my intention, and I believe it's Mills 58's intention, to continue to work with them to hopefully come to a completed resolution with those issues. So as Jason has said, I just want to thank the board, the consultants. Everyone's been very timely, very helpful. We're ready to conclude our presentation, and hopefully the board sees fit to close the public hearing tonight. Thank you.
While we're waiting through the chair, if I could, Jason, I believe you did agree that they would remain affordable for perpetuity. Did you not?
We did not agree to that.
Oh.
And we had been in discussion with community development and the mayor's office with regard to that. So the affordability restrictions have kind of vacillated between 30 years and in perpetuity, and the developer's preference on this would be to have the affordability restrictions run for 30 years. Sure. And by way of correction, 8 of the 13 units will be set aside for local preference, not 5. I went to law school, so I'm not good at math.
Anybody in the audience to say anything at all? Let's start with in favor. Let's then go on to Mr. Sheehan.
Good evening, Madam Chair, honorable members. My name is Bill Sheehan. I practice law in Peabody, Massachusetts at 8 Exeter Center Drive. Representing tonight VRRM LLC and Sideways LLC. They are the owners of the property next to the project, and also Wayside Transcorp, which is their business that operates from those properties. And I am pleased to say that we did make some progress on 2 of the 3 issues that you've heard me talk about from time to time. No question we made some progress regarding the notion of parking, getting rid of head-in parking and replacing that with parallel parking, assuring access, trying to create less of a safety problem. Those things we made some progress on. Unfortunately, we have not made progress on the 3rd issue, which you've heard me say from the beginning, and that is our concern about the propriety of this site for residential use. And all I want to say by way of summary is this. With all due respect to the chair, it is up to you to make the decision as to whether or not this is an appropriate site. For 100 years, this property has been used for industrial purposes. More recently, it's now been used for some commercial purposes, which fit in quite nicely with the industrial use. Now this proposal for residential use. 45 residential units, which are within about 30 or 40 feet of my client's property line, and my client has industrial uses there that are not compatible with residential uses. The proposal that we had made, trying to bridge the gap on this issue, was a proposed covenant whereby my clients would be protected from an action brought against them for them to stop doing their business. We are not seeking any protection from claims for personal injury or property damage or anything like that. What we are concerned with is a suit brought against my clients seeking to stop them from doing the business that they're presently doing. And with all due respect, they should be protected from that situation. You have the power to protect them. And I'm going to ask you to exercise that power and enter as a condition to the grant of the comprehensive permit, if you decide to grant the comprehensive permit, and that is to protect my clients with respect to their ongoing business. Now, you have, I don't know if you have all the papers, you've been deluged with papers in this matter, but I have brought with me a copy of what I submitted on August 15, 2022. If I may be permitted to hand it out. If you don't want to have it, then I'm just going to make reference to it. But what we said then was that we needed some protection, either by way of a covenant or by way of condition. And the condition that we proposed on August 15, 2022, was actually the following: that the applicant and its successors and assigns shall not sue or institute any legal action against an owner and its successors and assigns of real estate identified on Exhibit A, attached hereto, so as to prevent, limit, reduce, inhibit, or interfere with the present use or another lawful industrial use by each such owner of its real estate. Now, that was designed to deal with all of the property owners in the industrial park. The other industrial users apparently are not concerned, and so I don't represent them. I represent the folks that I've just identified. And so the condition that I had proposed on August 15, 2022 can be much more narrow, and the only beneficiaries of the condition need be my 3 clients. So I'm going to ask that you impose that condition. It would read, the applicant and its successors and assigns shall not sue or institute any legal action against the following owners and their successors and assigns, so as to prevent, limit, reduce, inhibit, or interfere with the present use or another lawful industrial use by such owners. And then you would identify for the, as far as that condition goes, my clients, VRRM LLC and Sideways LLC. So that's what I'm asking you to do tonight. I do also want to ask, I did not hear as far as the materials that you accepted tonight. The memo that we submitted on September 15, it covered our design engineer regarding parking, and I take it that I know you've received it, and I may have maybe I missed the identity of that object, that paper being accepted, but I want to make sure that you do have it. And with that, ASB. Good. So with that, I ask your consideration, and I thank you very much.
Thank you very much. Anything else? Anybody else? Hearing none, I would need a motion to close the public hearing.
So moved.
Second.
All in favor?
Aye.
We have 40 days to render a decision. We meet again on November 21st. Did you all hear that so far? You didn't hear any of it? I can't hear you. Oh, you're right. So, people at home who didn't just hear me because my mic was off, November 21st is our next meeting, and at that point, we will be rendering a decision. Decision will be read with all the conditions. If the decision has to be tweaked at all, we will tweak it, but there will be no more public comment. And there will be no public comment on the night that we render our decision. And November 21st, after that decision is read into the record and approved by us or accepted by us, we then will vote to accept that decision or to change it a bit and continue it. So November 21st, we will be hearing a decision on 58 Pulaski Street and the conditions. I don't think I need a second on that, do I? It's just an explanation. So there we go. And that's how it's done, everybody. Decision is ready to be done next month. Thank you. And now we are going to now hear our next 40B, the Tanwright Residences, LLC, which is 39 Wallace Street.
You didn't even give us an opportunity to thank you. Thank you for closing the hearing, and we look forward to the resulting decision.
So do I. Okay, let's go.
Good evening, members of the Zoning Board of Appeals. My name is Jason Panos, and I am the attorney for the Tanwright Residences, LLC, the applicant in the instant matter before you tonight, that being the 40B application at 39 Wallace Street. Tonight we are going to be talking about really what I consider the crown jewel of the proposal, that being how we manage stormwater on site, how we handle the sensitive nature of the location of the property. We designed this proposal with careful review of a report entitled Engineering Evaluation and Design Alternative Analysis from March 2019 that was prepared for the city of Peabody. This report evaluated and analyzed resilient design measures to provide flood protection during storm events in close proximity to the property. We have also carefully reviewed a memorandum by AECOM dated June 2020 for the City of Peabody Department of Community Development and Planning regarding the Lawrence Brook watershed outfall and green BMP design, also in close proximity to the property. To the extent applicable, elements of each report have been carefully considered in designs for the proposed development. Importantly, these considerations include stormwater retention and flood mitigation and the fostering of an active pedestrian streetscape. And the two, we believe, do coexist on this property. We proposed 2 pocket parks that you'll recall that really act as stormwater mitigation and create an attractive landscape for people to recreate in. Within the community, and obviously not just limited to participation by the people living in this apartment community, but by the community as a whole. And this was very important to us. We are very fortunate. This property is very unique because only about 0.2 acres out of the total, almost 2 acres of the property is located in a flood zone. And that is approximately located at the corner of Wallace and Walnut Street. All proposed residences are located either within the zone, flood zone X, or elevated at a minimum 1 story above grade in the location of the zone AE, which is that flood zone that we're all concerned about, that zone AE, with commercial units, parking structures and appurtenances located at grade in anticipation of the potential and future sea level rise and assumed increases in bordering flood zones. In short, this development is designed in a safe manner, eliminating any adverse impact on health or safety of the occupants, the residents thereof, and particularly the public generally from anticipating any flood hazards now and into the future. So with that, Tony's going to give the more technical presentation, and I will add very briefly that coincidentally the flood or the stormwater management peer review did come in. So I don't know if that's part of your packet tonight, but we were able to get a preview of that, and we're able to at least address the concerns that came out of it. And I'm proud to say that we really got ahead of it with our design. We anticipate a lot of the issues that they came up with, so I think we're all on the same page with your peer reviewers in that regard. So, Tony, please.
Thank you again for the record. Tony Capichetti, Hayes Engineering, 603 Salem Street, Wakefield, Massachusetts. Anyone who's been to the area knows that this area floods. The 100-year flood zone goes to elevation 15. What we've done is design this project not only not exacerbate that situation, but to help reduce it. Some of the recommendations in those documents that Jason brought up is that any development should enhance the stormwater characteristics and flood capacity of the area. They make some suggestions of under parking storage, pervious pavers, and integrating flood storage parks, which we managed to hit all those boxes in our design. There's some other projects, past and future, designed to help this area. The East End Veterans Park is green space as well as suppressed flood storage, and that's similar to what we're doing with our pocket parks. And then the city plans to do the North River Park and Riverwalk and some other work in that area that we look to marry our project to. This is the site in its existing condition. You're looking at the rooftops, pavement. The site is entirely impervious today. We've done our best to maximize green space. We've added a little over 11,000 square feet of green space on our site, plus some other areas off-site where we're adding some green space along the streetscape, but we're not taking credit because that is on the city's property. In this design, we have some flood mitigation areas. The depressed pocket park is designed to flood. This depressed pocket park is designed to flood. A stormwater swale in between the buildings is designed to flood up to elevation 15, as well as area that we can't take credit for. These are all required by regulation. Any work we do to disturb that bordering land subject to flooding, we need to provide equal compensation at a similar elevation. This under-parking area, which connects to the pocket park through 3 36-inch pipes, is designed to flood as well, but not come to the surface, and that provides additional flood storage. This chart, if it was at all legible, would show you that we match and or exceed the existing conditions versus the proposed condition at each flood storage elevation. And as we get to the upper elevations, we continue to exceed to the point that we provide in this regulatory flood compensation an additional 30,000, almost 900 cubic feet or 0.7 acre feet of storage beyond what's out there today. Then if we look at the under parking storage, which are these large high-density polyethylene chambers, these stand about 5 feet tall. They're underlain by porous stone, and these are proposed, 169 of these chambers under the parking area to connect, as was discussed previously, for an additional flood storage that's beyond what was required. And this doesn't even count towards this because it's not technically considered hydraulically connected without a free flow because there's pipe restrictions, but it will act in that way, and Horsley Witten agrees with us for an additional 30,500 cubic feet, resulting in 1.4 acre feet of extra flood storage. So that's basically, if you picture an acre of land, we are storing 1.4 feet deep over that entire acre of land of extra flood storage beyond what we're displacing. The review by Horsley Witten, they note that we have 11,000 square feet of impervious reduction. As such, we're only required to meet the stormwater practices to the maximum extent practicable, but they're looking for using some of that subsurface flood storage for stormwater. And we were a little bit light on the details because there's a million different ways to approach this, and every engineer kind of has their own insight, and we wanted to make sure that Horsley Witten agreed with us. So we didn't tie the catch basins in originally because the original concerns were maximizing flood storage. And as I'll get to this later, some of the other concerns brought up by people in the areas, in the smaller, more frequent storms, the catch basin system seems to get overwhelmed out on Walnut Street. So our plan is to now take some of these smaller storms and redirect them to that compensatory storage to try and alleviate some of those issues out on Walnut Street in the smaller storms. And as it was kind of expressed to me today by one of the abutters is, I can plan for the 100-year storm event. When there's a hurricane coming, there's a million news flashes. In the summer, when there's a quick thunderstorm burst, I have no time to prepare for that. So those are the concerns that we were getting from at least one of the abutters, and that's something that we're going to work towards. They look for changing some of the walkways to pervious surfaces, which we're open to doing. So on the on-site walkways, we'll go to pervious surfaces, adding some additional TSS removal for the parking lot. That would only be possible by tying the parking lot into that additional storage, which is what they're recommending, so we have no problem doing that. It's, generally, they're looking for additional levels of detail that weren't provided in the original filing, just kind of how we're going to handle the on-site drainage. They recognize that it's an improvement over existing conditions, think we can do a little better, and we do too, because they seem to agree with our overall approach. So that allows us to make these minor changes. And as I said, Century Tire approached us today. I met with him this afternoon. He kind of went through his issues, pointed out the catch basins, gave me some videos, so I have some information I'm going to try and tie to those storms that he observed these issues, and try and reverse engineer and find out where the problem lies and what we can do to alleviate that. The conclusions are that the area is prone to flooding from the North River. We accommodate this condition. We provide additional mitigation beyond what's required by the regulations, to the tune of 61,000 cubic feet. If you took that over our entire parcel of 84,000 cubic feet, that's about 8 3/4 inches of storage over our parcel. So if you think of that entire block there, and you put almost 9 inches of water on it, that's what we're taking out of the 100-year storm beyond what's required. We're sensitive to these issues. We've looked at the planning documents. We've done our best to address those, and now we're getting some issues from concerned abutters, and we think that real-time data from those affected is just as important as these study documents to kind of look at a global issue. So we're working with those abutters, and we're hoping that we can respond to this Horsley-Witten review, continue to work with the abutter, and address some of those concerns out there. If there's any questions on how the stormwater functions, I'm more than happy to try and answer them for you. I'll get the overall plan back up. So, thank you.
So we've done traffic already, and tonight we've done stormwater. What would you like to hear about at the next meeting?
I think water and wastewater we could probably
Yeah.
combine because they're pretty minor.
And of course, at this point, we're just waiting for peer review to come in. So as that comes in, we can tweak and adjust what we've presented, and hopefully, narrow any differences and come up with a nice, tidy memo at the end of the day. Hopefully sooner than later.
Okay, I just want to do two things. I'm going to do this for you. A motion to accept the September 16th, 22 Langley memo with signed peer review agreements, and a late October 6th Langley memo with traffic peer review responses.
Second.
All in favor?
Aye.
And I also just need to know if there's anybody in the audience, the couple of people that are here, does anyone want to speak? Okay. Say, are you good?
Yeah, Madam Chair, I don't think we got traffic peer review in yet. I think that was stormwater. You said traffic.
With traffic peer review. Oh, it was stormwater? Sorry.
Oh, I didn't mean to call out a mistake. I just wanted to correct the record, that's all.
Stormwater, okay. That's been corrected. That is, and also been accepted. Okay, great. Hearing none, thank you very much. It was an informative presentation, very nice. I need a motion to continue this till November 21st.
So moved.
All in favor?
Aye.
Any opposed? Okay, then that's a wrap, people. Thank you very, very much.